So, dear friends, this is the part 3 of our discussion with reference to the perjury. This is covered under Criminal Procedure Code, Section 340. We are discussing Chapter 26 of the Criminal Procedure Code under the title Provisions as to Offences Affecting the Administration of Justice. I am just deliberating this for those students of law and advocates. You can hear it like a song. And exactly the subject matter will be discussed. But it's in like a teacher teaching to the students is the subject. You will be getting it now. We'll go to this section 340, subsection 1 of the CRPC. When upon an application made to it in this behalf or otherwise, any court is of opinion that it is expedient in the interest of justice. That is where the entire case is running after that. Expedient in the interest of justice, you have to underline. That an inquiry should be made into any offense referred to in clause B of 195(1)B subsection. A is about 195(1)A will be about a public servant, like a revenue official. You want a legal hair certificate, you go there, you suppress the evidence and then try to take it, or you collude with the revenue officials. That section will apply. That is also CRPC. Whereas this is you are making before a court. Court means any court. That is what we'll come to. Which appears to have been committed in or in relation to a proceedings in that court. That court, whether it is a high court, whether it is an appellate court, or it is a lower court, when the offense is committed there, then that court only you have to approach. As the case may be, in respect of a document produced or given in evidence in a proceeding in that court, such court may, after such preliminary inquiry, underline, preliminary inquiry has to be conducted, if any, as it thinks necessary, A, record a finding to this effect. See, this is a criminal law. Strict interpretation is there. So many a times the court would have ordered for inquiry just by that. Without recording the facts, then that will become a nullity. Record a finding to that effect. B, make a complaint thereof in writing. So you find the recording and thereafter you have to see I will come back again. Make a complaint thereof in writing and send it to the jurisdictional magistrate of first class. These are the ABC. D and E also is there. Sufficient security for appearance and bind over and all that is there. So this is the broadly still that 1 is there, 2 is there, 3 is there, but I am confining to the scope of section 340 subsection 1. So I'll run it fast now. When upon an application made to it in this behalf or otherwise, any court is of the opinion that it is expedient in the interest of justice that an inquiry should be made into any of the offences referred to in the clause B of subsection 1 of section 195 CRPC, which appears to have been committed in or in relation to a proceeding in that court, or as the case may be, in respect of a document produced or given in evidence in a proceeding in that court, such court may, after such preliminary inquiry, if any, as it thinks necessary, and record the finding to that effect, make a complaint thereof in writing, send it to a magistrate of the first class having jurisdiction. D, take sufficient security and bind over. All this has to be complied with. That is why one has to read this. See, making a false statement is a menace. Though many of us don't use that, because the entire proceedings, administration of justice is vitiated. But then over the judgments, a series of judgments, including what lordships have delivered, if you see, even though the offense is committed and confirmed, then punishment is not given, or the 341 is not invoked, because this is a discretionary jurisdiction. And so we are going to discuss that in detail, though we have explained you relating to that law. But now I would like to make it as easy for you to hear and then refer to various cases, that I'll give you short explanation for all the cases. Now, the discussion, if you see, what the Honorable Supreme Court constitutional benches have referred to about this menace. Before we go into the subject, it is the judicial process or administration of public justice which is direct and immediate object or victim of these offences, as the purity of the proceedings of the court is directly sullied by the crime of perjury. The court is considered to be the only party entitled to consider the desirability of complaining against the guilty party. So you do the comment. It is an offense created against me. If you see Iqbal Singh Marwa's case, what happened? Their two brothers are there, and the elder brother died, and the younger brother, very intelligent person, he created a will, and he created a will as if it is done by, signed by, forged, that will of his brother. And then he himself appointed as the trustee of the entire properties of his brother, and then applied for probate. And for the benefit of his own family, when the brother as a widow, and this child is there completely, and you find at that point in time when he said to have signed, he was in Japan. He was a highly educated person. So that was the case. So it is a document which is forged, based on which he is able to execute it to the detriment of the actual beneficiaries. You understand? So this become a normal thing. Even Lordship SMJ recent writ petition disposal, again the same thing was found. Two sisters, one brother is there. The brother wanted to legal hire certificate. He went to the revenue divisional authorities. Since they are not giving, this man might have known some law, immediately filed a writ petition. And then when they found that in that writ petition, this person has forged, he has suppressed the information that he had brothers, sisters. So he is trying to take that, when the matter comes to the High Court, writ petition, the court may order, because it's not necessary court should know everything. And so it is an offense. False statement in the affidavit, suppression of the evidence, material evidence which you know, and you make statements which you know to be false, and to please the court. You are supposed to come to the court with clean hands and tell the facts of the case for the judges to come to a conclusion. That is the purpose of justice administration system. Now, here further the Honorable Supreme Court in this constitutional bench, full bench of Honorable Supreme Court, in Sabaji Naik versus Pradhanya Prakash, 2017, latest judgment vote 7 years back, 5 SCC 496, in para 13, I'll read out that. I'm giving the introduction to this. This court must view that with disfavor any attempt by the litigant to abuse the process. The sanctity of the judicial process will be seriously eroded if such attempts are not dealt with firmly. A litigant who takes liberties with the truth or with the procedures of the court should be left in no doubt about the consequences to follow. Others should not venture along with the same path in the hope or on a misplaced expectation of the judicial leniency. Exemplary causes are inevitable and even necessary in order to ensure that in litigation, as in the law, which is practiced in our country, There is no premium on the truth. If this particular judgment is to be relied upon, how is it connected to Dr. Jayachandran's judgment there? If somebody asks, the Lordship should have imposed some costs on that to be paid to a legal aid service. That could have been, this is a constitutional bench, full judge bench. So there are, see the way in which the judgments are presented, that's no doubt. It is clear that the madam indulged in, the court confirmed that she indulged in the fabrication, falsification of evidence. And on the interest on these things, fine. Punishing her is not correct. But then the discretionary jurisdiction, when it is used, there should be something like, they should also realize that they should, others, because the crime is something, societal impact is also to be taken into consideration. So in spite of the fact that was a landmark judgment, in my opinion, the way in which the judgment is taken, but I humbly submit that you should not give opportunity. The two things will happen. Now everybody will think nothing is going to happen. Nothing is going to happen. We'll just, like contempt proceedings should come. Everybody knows you can do something and then apologize. The court will have to consider something like that. And the only thing is, whether it's a sincere apology or there's no remorse, something like that. Then what is the purpose of fighting that? You are authority of the court. That court is the ultimate savior, the guardian angel of our fundamental rights. And therefore, this is one thing the courts will have to consider. I repeat that Sabaji Naik versus Pradanya Prakash Kadika, 2017, 5 SCC 496. This is a very important consideration that should be considered, while, because it's most likely today, of course, the law is, many people are getting to know. Earlier, law has become as the domain of few people who are in a position to get away with all these things. And so the heartburn will always be there. Therefore, it has to be, some balance is to be conducted. It's my humble opinion. If you take this question, even in this, next is the procedural issue. We will come to that procedural issue. And as of now, this is the background, because you can't do it and escape. Whereas in this judgment, of course, that balancing is at that juncture. Having confirmed that she has committed itself is a big blow to her. And judge's lenience, balancing, being a lady, married women, and then otherwise, I don't want to say, but still, one is looking from the angle of that person, and second is looking from the societal angle. The idea is everybody wants to commit crime, but 3% only that you could see the phenology and criminology. The fear that they will be punished, fear of punishment is more important than the actual punishment. That's and in Indian laws are such, laws are very good, but then the fear of law is not there. Therefore, they are committing the things with impunity, is one view. So now we will go to this is a legislative changes have taken place. Criminal Amendment Act 2005, Act 2 of 2006, 340. Now, this is 12/4/2006 notification, and it will come into effect from 16/4/2006. So, I'm just focusing on the law with regard to what is decided in decided cases are there. You all can read that the page 1532 of CRPC. I'm picking up so that you can easily pick up the issues central to these judgments and all. So one very important point we come across is when you are arguing your case. Now, everybody will be, if you are arguing like a complainant, then you want that the court must take cognizance of the perjury committed by them. Then it is the court will be thinking in a different angle. I'll show you what is the law that has been developed. Then how to convince that court to make decision in your favor. Understand? It is not you can accept, no, it is going to be like that, courts will decide like this. You have to convince the court based on circumstances of the case. It's a discretionary jurisdiction. Therefore, you need to use this constitutional bench judgment. That is my humble submission. I'm talking from the complainant's angle, and then you have to interpret it if you are the other side of the story. The object of Section 340 CRPC is to ascertain whether any offense affecting the administration of justice has been committed in relation to any document produced or given in evidence in the court during the time when the document or evidence was custodial, and whether it is also expedient in the interest of justice to take such action as required under 340. So two things are going to be a biggest hurdles for us to cross. The one is administration of justice and expedient in the interest of justice. So when you are trying to attack as a complainant's counsel, you have to spend a lot of time. One is establishing the facts that there is a commitment. Second is procedural facts. Whatever that 341 says, you have to ensure that judge does that. Even a small mistake that will be dismissed. You have procedural infirmity. And we are going to see most discussions in the constitutional bench. The latest judgment also has come starting from Pritishwar State of Maharashtra long back, and in 2020, the 3-judge bench headed by Justice Counsel is clearly said that the respondent has no right to in the proceedings. It is the court which is offended party because the court was cheated by way of these false statements, false narratives, suppression of evidence, contrary to the facts that have taken place. So it is for the court aggrieved to decide. But court cannot decide like a private complainant. You understand? So even the judgments are saying, however difficulty that person may face, really would have been affected. That's what the word is used. Then it should be looked in entirety, in toto. What is the impact on the society? Public interest, administration of justice, public interest, expedient in the interest of justice, all are linked to a public awareness. You understand? So if you take, for example, when the Honorable Chief Justice of India, if you see it, friends, the present Chief Justice, in my opinion, is extremely good. The amount of service he has done for access to justice is immeasurable. And be as it may, the video conferencing links, slowly, steadily, digitalization, it is very difficult to bring in changes in a system which is managed by the old people, 60 plus people, the top advocates and all. They resent the technology, dynamic changes. That is a resistant to change is there, everybody. But then the way in which he brought in among the entire system is highly appreciated. And when you see the way he handled, lordships handled these electoral bonds, and everybody has, I'm sure everybody would think is God of democracy, protection. Excellent. So therefore, different judges, different lookings and all, it's evolving jurisprudence. Because generally, if I feel so, many a times the concerned judge of that particular court, when the perjury petition is filed, not in full control of the subject like other things. You understand? Therefore, it is all the more important for you to convince the judges about the impact on the public interest. That's my humble suggestion and opinion. So here what they said is that these all proceedings, 340, in all courts, tribunals, irrespective of the fact whether the matter in a court in which allegedly an offense mentioned in section 195 of the code was committed, was a criminal case or a civil case. In Iqbal Singh Marwa, if you read, the constitutional bench analyzed, suppose in a civil case, in the affidavit, the person makes false statement or he submits false evidence, and then you are to bring in. So what is the concept of criminal proceedings versus civil proceedings? And the law was decided there. We will see later. It is not relevant right now. And here, if you see, the law says, when should you take cognizance? That's ultimately. Like, let us have a situation, because I'm fighting for the complainant. So I need some tangible information to make sure I'm winning the case. So that one comes to Supreme Court, full judge, full bench, that you keep it in mind. Though the wide discretion is given to a court under this section, the same has to be exercised with great care and caution, inasmuch as one of the objects of the section is to provide safeguard against the frivolous and vexatious prosecution. Jogindernath versus Shamlal, where the earlier criminal proceedings, that is okay, first step. So here the court is taking that frivolous, continuous litigation. That is where the judgment of Honorable Madras High Court is relevant. That is definitely, the lady is settled well, peaceful. That fellow also is there. No way it is going to help the society by doing, except that something in recognition of an offense made, the lordships must have given, is my humble thinking. Then, when will you apply offense? It is only in glaring cases of deliberate falsehood amounting to an offense under section 193 and 195, where the conviction is highly likely, probability of occurrence is very, very high. Then only the court should direct the prosecution. This Ritlal was a state of Bihar. That was the judgment. So this is being repeatedly emphasized in every judgment, that the probability of by the court, when court in inquiry must decide if this is a criminal proceedings you are ordering, and will it be going to definite conviction will be there. You please see, with regard to defamation, section 499 and 500, you can directly go as a private complaint. And there are judges, they will not take it very seriously, defamation. And civil consequences like blacklisting a person, they may not be worried on that, whether opportunity of being heard and all. Some people. And some people will take it very seriously. I was thinking, once I was, my friend, one Mr. Ram Subramaniam, Justice, was there. It was long, 20, 25 years. He became a judge in 2000. Then he used to keep telling me how the judge's mind will be. Suppose if a public prosecutor becomes a judge, and he will be so prejudiced against the police that he will not believe whatever the police says. So that also is very important factor to be considered like that. So these all points, in a legal strategy and court crafting techniques, we have to see how the judge mind is. Some judges will think, what is defamation? Now you see Kejriwal is there in the Supreme Court. He is telling, I'll negotiate and settle it. But the others may not think it as important. You understand? That is where you have to see which judge, which bench it goes and all, how to deal with it and all. That is also plays an important point. One is you are trying to convince the lordships about your case, whether they will take it or not. So their preferences, prejudices also one has to be taken into consideration. So it is not that you think everything is correct and expect the judges to decide in your favor. And that is a point has to be kept in mind. Here, my friends, the lordships, when they started, in the judgment, he took a procedural issues, para 11. Para 11 of the judgment, Lordship has used that Amar Singh Nathaji versus Hardik. There the procedural points are emphasized. If you see, Lordship has taken the case that which has indicated the procedure to be followed by the courts in forming an opinion before lodging a complaint submitted. That then he went through that. So first step is, this is an important point for any of us. When you are presenting in your affidavit, how the judge will think. So procedural infirmities, anything is there. So judge also is first testing. First para 11 started with the settled principle, the procedures, whether the procedures were complied when the judge was the sessions court ordered. Because here what happened, there was a complaint made by the husband and the sessions court decided, yes, she has committed the thing, and then referred the matter in 340. 341, she applied for appeal before the High Court. And the High Court is passing this order against that the decision of the Sessions Court. So therefore, one has to see that whenever you are filing, you are arguing the matter, how the judges will be looking. Facts of the case, then procedure, because criminal law procedure is very important. Anywhere, any procedural infirmities, you get a stay. Understand? For example, in a disciplinary proceedings, a bench discipline, the provisions will have to be gone through. In that provisions, it says that the members of the board, the discipline authority should consist of the members of whole time members, it says. Members means here the intention is two. And therefore, if one single judge sits, that's all, the case is dead. Stay will be granted. Therefore, that is, similarly, it is more because that have a disciplinary case against a professional involves blacklisting. Serious offense it is going to be. And if you can see, ICI was Ratna, beautifully explained what is the impact on reputation of a professional, the disciplinary authority's wrong decision. Yes. Now, if you see para 12 of the judgment, it is expedient in the interest, in the ends of justice, on my part to file a written complaint against the respondent before the Metropolitan Magistrate, Georgetown, having jurisdiction to take the appropriate criminal action against the respondent for filing false affidavit, as it appears that the respondent has committed perjury to have a wrongful gain. Actually, there is no word called perjury in the criminal law. You understand? False statement only is defined. There is no perjury. But then it has come like that. Anyway, wrongful gain. No notice is required to be given to the respondent. That is clear. That is a procedure. In case you have ordered a notice and taken their submissions, in one case, we were operating, it's IDBI Bank is the respondents. And then the NCLT allowed the additional Solicitor General who retired. He appeared 16 times. He appeared 16 times and 324 pages rejoinder was submitted. And since Advocate Solicitor General is 16 times means 80 lakhs of rupees the bank has paid the fees for that. And when I was telling, no, this is illegal, allowing him, then he went to the extent of hours together, he was arguing, and he went to the trial of the proceedings itself in that NCLT. And the members were listening 1.5 hours listening. And this page is taking, where is the document? Where is the 65B? And where is this, that, and all? Then finally I have to tell them this is constitutional court decision. If it is overlooked, means that there will be an amount of contempt, my lords. Please understand, I showed the judgments. Again, it was posted, of course. So, because it is not the mistake of the courts and all, perjury is looked as if it is something a useless case, like that. But the importance is not recognized. That is the important thing. So here, this this 253 Honorable Apex Court reported in 2002 SEC. That is the same case in para 11. That Amar Sang Nathaji. That was the point for discussion. So we will. Only thing is the procedure. You know, if you see the different cases, I will just read out with regard to the procedure. That is notice, the opportunity of being heard to the accused. This is where the people have to make it clear. There is no statutory requirement or legal obligation cost on the court or authorities concerned to afford an opportunity of hearing to the would-be accused against whom magistrate might initiate prosecution proceedings. This is Pritish versus State of Maharashtra, landmark judgment. And notice to the proposed accused not necessary before passing the order for institution of the complaint. The proposed accused has no right to file documentary evidence in defense. And notice issued by court without going to the facts or merits of the prayer is illegal. See, if you read this, all the judgments need not be given, then that means discretionary issue will come into the picture. Though it is said that in Pritish versus State of Maharashtra, the person affected, he filed the case. Then they said, you can't file it as a right. Then the question arises whether the court can, in its own discretion, feel and the merits of the case allow. That is the next point you can say. Then when the court, then they said it is illegal. Illegal, nobody can do. Discretionary jurisdiction should be exercised with reasons. Otherwise, it will become arbitrary. Therefore, and finally, the constitutional bench has decided, Jaspir Singh was State of Punjab, 2020, by Justice Abhay Oka, Justice Kaul, and other three-judge bench. Therefore, it is mandatory for the tribunals to, or the concerned court, to not to give an opportunity. Then it will become arguments. What magistrate should do is the High Court will be doing. What magistrate should do will be done by the tribunal or the civil court. It is not permitted. That is the point. So we will continue with this discussion, and part 4. We'll go deep into the subject, which is on for the practicing lawyers. This now, it goes out of the normal thinkers, but it is a specific core subject we are talking about.